Thank you very much indeed. Stephen Kinnock.
Thank you very much, Chairman.
Good morning. A question I had about the arbitration panel. So it's made up of one representative of Ukraine and one representative of the European Union institutions, if I'm right. And then there's a third party from another country. How is that third seat chosen? Who decides which country that person should come from and what their qualifications are for the role?
It's chosen by the two. It's chosen by the two sides, but that has never happened in practice so far, so there has been no need to apply the arbitration procedure. So I cannot name any examples like which country representative was chosen and specifically why. But the agreement itself does not give a lot of detail at this stage. So it's just that the two sides choose the third neutral party.
So it's not clear what the process would be, whether it would be the European Union proposing somebody and Ukraine responding to that, or?
It's based on the agreement of the two sides.
Right, okay.
Maybe one relevant point about the Court of Justice and why it is the Court of Justice in the agreement that has to interpret the law. In our case and in these agreements, it is the European Court because it's all about EU legislation and its approximation. Now, should the UK conclude an association agreement or any form of association agreement with the EU, it will probably not be all about the EU legislation because EU products have to access your market as well. So the configuration there, or who interprets what, might be completely different. In our case, the whole essence of the agreement is that Georgia approximates its legislation with the EU legislation, and the questions may arise what exactly that legislation says, and then it's the EU court that interprets and not the Georgian court. But it doesn't mean that, I mean, it can be a completely different setup in your case. Because it's a bilateral thing. In our case, it's a higher level of asymmetry in that respect.
Okay, thank you. I'm interested in this idea of the a prudential carve-out, I think it's called. So in the services sector, and particularly in financial services, if there is a view that there could be, because of the behaviour of the associate country, such as Ukraine, it may somehow cause financial instability, the European Union can revoke market access at any point. Can you give a sense of how that might, what might trigger the revocation of, unilateral revocation of market access based on anything that might be happening in, for example, the Ukrainian financial services sector or the Georgian or any other for that matter?
Yeah, definitely referring to Article 126, which is on page 2014.
Exactly. That's the one.
And yes, especially in case of let's say, imprudent behavior of a certain bank, which we were seeing in recent times in Ukraine. Certain licenses may be revoked, or with regard the protection of investors or depositors, certain safeguards may be imposed. We can theoretically imagine a situation that Bank X has an access to EU internal market in financial services and takes deposits and provides services. So this possibility may be stopped for the reasons of prudential carve-out in an extreme case.
And that would be done entirely unilaterally by the European Union. There's no consultation. There's no sort of advanced warning and request for feedback, or a grace period to change the behaviour, whatever it is that might trigger it. It is just a unilateral decision by the European Union.
The text verbatim says that each party may adopt or maintain measures for prudential reasons. There are no such things as you mentioned envisaged in the association agreement.
Okay, thank you. Thanks. This area of sectoral negotiation, so in areas like mutual recognition of services and labour mobility, there can be these carve-outs negotiated on a sector-by-sector basis, which sounds a little bit like the Switzerland arrangement. Can you say a bit more about how that would work in practice? What would be the governance of that? Which European Union bodies and which Ukrainian bodies would come together and engage to agree on how to get more liberalisation in particular sectors? How does that work in practice?
I can comment on, for example, such services as notary. For example, it's clearly stated in the agreement that there are certain reservations on that particular issues, that only citizens of Ukraine can perform or are permitted to supply notary services. So my understanding is, because it's still very fresh, the agreement as such, my understanding is that each regulatory body which governs particular type of services horizontally will be consulted or will be advised in that particular regard.
Okay, thank you. Just one final question. Just on the issue of ratification, so the legal basis being Article 217, and that makes provision for some key aspects of the DCFTA to be implemented before they've been ratified. My question on that is, what happens if you've started the implementation, but there is a ratification process going on in a national parliament in parallel, and then the national parliament says no? Does the entire implementation of that provision stop right across the board, or is it it continues even though the national parliament has refused it? And my second related question is, if we were to go down the road of a DCFTA as the basis for the future relationship post-transition between the UK and the European Union, what do you think the chances are of getting a DCFTA negotiated and ratified, or the process moving forward, before the end of a transition period, assuming that the transition period will end in December 2020? Is it realistic to expect that it could be done in that time frame?
Yeah, a couple of points in response here. One is the provisional application business. There, in the DCFTA case, the largest part of the economic content of the agreement will be fully applied upon signature without waiting for ratification.
Yeah.
Then the question is, what happens if the ratification runs into trouble? By the way, we had the case with Ukraine when the Dutch government rejected ratification, and it took, I don't know, a year, was it, before the Dutch got round to ratifying. Well, in that particular case, the provisional application continued. If, however, there'd been a definitive refusal of ratification, then the game's off. You're back to status quo ante.
Okay, thank you. Thanks.
Just to add regarding the timeline, so actually it is possible to keep parallel tracks of negotiating the DCFTA and the association agreement, and this was the case for Ukraine and for Georgia and for Moldova as well. So the negotiations actually started at different points in time, and finally all was wrapped up in one agreement, but I think it could be negotiable to just have a DCFTA, and it would maybe be easier to negotiate. Georgia negotiated it in less than 2 years, even though there was some preparatory period to prepare the negotiations, but still. And then in parallel to work on other issues that are not related to DCFTA, because in a way it will ultimately be a part of the overall agreement that you will conclude, but you can have a situation where you first have a trade agreement and it applies without requiring the ratification of the EU member states, because trade is exclusive competence, and Commission signature, like signature of EU institutions, is enough in that case, and no ratification process by the member states. And the other process then goes in parallel with ratification and all that, and that part enters into force at a later stage.
Okay.
Could I add on to the question of the timing and what can be done before 2021? It's very interesting to notice that Ukraine, who negotiated first it took 7 years to do it. Then Georgia came along later, and step one in the process was that the Commission took the Ukrainian text, deleted Ukraine and inserted Georgia, and tabled that. Or basically the template was used as the starting point, and the result was it only took 2 years. So this is an extremely important point, in my opinion, my personal opinion, for the British negotiator to appreciate that here you have an absolute gold mine of agreed, verified legal language, which takes a huge amount of time to negotiate when you're starting from a blank page. So that could be used. Now, other point that Tamara was referring to, I think, there are parts of the business that are very important that are referred to in the text but are negotiated with separate agreements. And the civil aviation area is one, and the Energy Community Treaty is a second. Both of these are very big things. These can be negotiated separately.
Okay, thank you very much. One wonders